Okay, good afternoon, everybody, and welcome to today's session. Today we are having an interesting panel, 3 chairpersons, very able chairpersons. I'll ask them to kindly introduce themselves, just giving a very brief introduction about themselves so that we delve into the topic of the day in the interest of time. I'll start with the only gent on the panel, Mr. Nyongesa.
Thank you, Joy. My name is Eric Nyongesa Wafula, the chair of the Tax Appeals Tribunal. I'm an advocate, now having done about 23 years of practice. Ordinarily, I used to practice in Mombasa and Nairobi, and I'm happy to be here to interact with my colleagues.
Thank you so much, Mr. Nyongesa. I'm sure we will reap the best out of the 23 years of practice in this short session. Next, we need to have Beatrice Kimemia introduce herself.
Good afternoon. My name is Beatrice Kimemia, Chairperson, Cooperative Tribunal, Chief Magistrate. Welcome to this session. I hope that it is going to be lively and interactive. Thank you, Joy.
Thank you so much. Thank you. Looking beautiful in this Friday afternoon. It definitely is going to be awesome. I'm also looking forward to a very interactive session, a learning session. Yeah, so last but not the least, definitely, we have our own Miss Namisi. Yes.
Thank you, Joy. I think having listened to the 2 introductions, I am the least, at least in experience, yes. My name is Helen Namisi, and I am the chair of the HIV and AIDS Tribunal. I'm an advocate practicing in Nairobi. I don't want to say the number of years because it's definitely not as many as the other 2 before me.
Oh, great. Thank you so much, participants, for joining in. We are 6 minutes into time. We've had about our very brief, I know I gave them probably 15 minutes to talk about themselves. We'll get more. But courtesy of the seats that they hold, the positions that they hold, I'm sure they're going to tell us much. So again, today our gent is going to have a field day. So I'm going to start with you, Mr. Nyongesa. Being the chairperson of the Tax Appeals Tribunals, kindly let us know what is the composition of the tribunal?
Yes, thank you. The tribunal ordinarily under statute is supposed to be a chairperson and 20 other members. The statute restricts the number of advocates to 5. So we have 5 advocates and other members from different disciplines. Many of them, some who have worked with the Kenya Revenue Authority before as commissioners and tax practitioners. We also have lecturers in tax. So ordinarily we sit in panels, so a panel of 5. So every advocate ordinarily chairs a panel.
Interesting. 20 with 5 advocates and each advocate chairing a panel. Next we go to you, Ms. Namisi. What is the composition of the Tribunal on HIV and AIDS?
Thanks, Joy. So the HIV and AIDS Tribunal is composed of 7 members. You have the chairperson, 2 advocates. You have 2 persons who are licensed to practice by the Kenya Medical Dentist Practitioners, that very long board, that one. So 2 doctors, generally speaking, and then 2 persons with specialized knowledge in the area. And basically, the way we sit is the quorum is chairperson plus 4 other members.
Great. So quorum is 5. Yes, Madam Beatrice. How tell us about also how the tribunal, the cooperative tribunal is constituted.
Thank you, Joy. The Cooperative Tribunal is constituted of 7 members. The chair and the deputy are nominees of the Judicial Service Commission. Then we have 4 advocates, 2 other advocates. One is nominated by the Law Society of Kenya, and the other is a nominee of the minister. Then the 3 other members are specialized persons in the cooperative movement, and they are nominated by the apex body, which is the Alliance of Kenya. The quorum is 3 generally for hearings. However, the chairperson, the sessions are presided either by the chairperson or the deputy with 2 members, or the chairperson and the deputy and a member. However, if there is any reason where either or both members are not present, then the chair or the deputy can sit alone. And then in interlocutory injunctions, the chair or the deputy can issue orders in temporary injunctions. Thank you, Joy.
Thank you so much for that detailed explanation on the composition of the tribunal that you chair. I'll still go to you. So will you let us know what cases the tribunal handles? What does your day-to-day activities, what cases do you handle in the tribunal?
The cases are determined, or the act is clear on the cases handled by the Cooperative Tribunal. This is under Section 76. Number 1, the Cooperative Tribunal has unlimited geographical and pecuniary jurisdiction. We handle cases generally of appeals on such charges by the Commissioner for Cooperative Development. Then we have refunds of shares or dividends or deposits. Then number 3, we have loan defaults. Number 4, we have management issues. Number 5, any other matters which may be referred by under the SASTRA Act. That is, you know the SASTRA Act. If it is not clear, you can ask which is the SASTRA Act. And then we also have decisions when the Commissioner for Cooperative Societies either revokes or suspends licenses of cooperative societies, then under that, we can handle the cases. We also execute our own awards, and we also do contempt proceedings under Section 58 of the Cooperative Societies Act. Thank you.
Thank you so much. Thank you so much for that information. I want to remind the participants who are still streaming in and those we began together that the chat box remains open for questions on the go. If you do not know the SASTRA Act, this is the place where you can raise it. Anything that you may need to know from our panelists, kindly raise it on the chat box and we will be able to respond to the same. So quickly we move to you, Madam Helen. Kindly let us know what sort of cases the HIV and AIDS Tribunal handles?
Thank you, Joy. So the HIV and AIDS Tribunal handles cases relating to breach of the provisions of the HIV and AIDS Prevention and Control Act. I know it is a mouthful. So we commonly call it HAPCA. So what are the provisions of this act? Some of the cases that come to us relate to when you're tested for HIV without your informed consent, when you're tested without pre and post test counseling, and these are mandatory under law. When there's disclosure of your status to third parties without consent. And most of these cases also revolve around stigma and discrimination on the basis of one's status. So the kind of people who come to us, or the kind of cases that come to us, are instances where the individuals may be coming because of stigma relating to their real or perceived status. So it's not necessarily only those who are HIV positive, but you may be affected by virtue of living with a person with HIV, or even the fact that somebody thinks that you may be positive and therefore decides to stigmatize you or discriminate you in one way or another. So it's not purely just for those with HIV. We say it is for those who are infected and affected by HIV. Thank you, Joy.
Infected or affected, which clearly means that everyone here who's in one way, if you're not infected, you are definitely affected. So thank you so much. Mr. Nyongesa, delve us in tax tribunal. What do you handle?
By its very name, you see that we are an appeals tribunal. So that means that a decision must have been made. So ordinarily, we deal with appeals emanating from decisions by the commissioner, either it can be customs or any other commissioner of the Kenya Revenue Authority. So what happens ordinarily is that, for instance, in a very basic situation, you've been served with a tax assessment. Before you come to us, you are supposed to appeal against that decision or raise an objection to that decision with the commission, the relevant commissioner. So once the commissioner has made a decision on your objection and you are not satisfied with that decision, that's now when you appeal to us, so that you come to us by way of an appeal against a decision made by the commissioner. So you appeal against a specific tax decision. So there must be a decision made. We've also had situations, because the Act says the tax decision or any other matters arising from a tax dispute. So ordinarily, if it's not an issue that involves constitutional issues or procedural impropriety, which may require orders in the nature of judicial review, we've also been able to undertake, like you may find, like at times they have not been served with an assessment and they want to enforce a tax. What they always do, issue agency notices to your bank or to your creditors. So in the event that they have not served you and not given you an opportunity to raise an objection, and they've just tried to issue an agency notice, you can also come to us for purpose of lifting of such agency notices. So basically, our jurisdiction is wide, except in matters constitutional or which involves procedural impropriety.
Thank you so much for that. Today we are looking, it's a series, so we are looking at 3 tribunals. For those of us who are joining us right now, Karibuni, you're most welcome to learn with us. We're having Ms. Beatrice Kimemia, who chairs the Cooperative Tribunal. We have Mr. Eric Nyongesa, who's the chair for the Tax Appeals Tribunals, and we have Ms. Helen Namisi, who chairs the Tribunal on HIV and AIDS. So I also again want to remind you that we have an open chat box where we're going to be receiving your questions on the go. Questions emanating from what our panelists are sharing, questions that you've heard that have gone unanswered related to these 3 tribunals. You're welcome to use the chat box, and the responses will be given by our very able panelists. So I will still do a follow-up question on the quite interesting tribunal, which is the Tax Appeals Tribunals. You mentioned that there must have been a decision for the matter to come to the Tax Appeals Tribunals. So someone may be sitting here wondering, then how exactly do I approach the tribunal? How does one file the case? Just take us through step for step how someone does this. Here I am, I have a decision. So what next, Mr. Nyongesa?
Yes, thank you, Joy. Once the commissioner has made a tax decision following you having objected to an assessment or a demand for tax, once you've served with that decision of the commissioner and you've been duly notified, most of the time now they are notifying you on the iTax platform. And that's why as lawyers, we need to be checking our iTax platform, because many people are being caught unawares, because they will do an assessment, they may send you an email, or they may serve it on your iTax platform. So most of the time people will come and say, I was never served. But when you check on the iTax platform, it was duly served. So ordinarily now what they're doing online decisions. So they will serve on iTax or send you an email, because you normally ordinarily provide an email. So once you are notified, you have, within 30 days, you are supposed to file a notice of appeal to the tribunal, which you also serve the commission, indicating that you want to appeal against that decision. So once you file the notice of appeal, then you have 14 days within which you should file before the tribunal a memorandum of appeal and a statement of facts. The statement of facts, of course, you will indicate all the facts leading from the assessment, the documents that you intend to rely on, and then you also need to file with us that tax decision that that was made by the commissioner. So those should be filed within 14 days of you having been served, within 14 days of you having filed the notice of appeal. So once those documents come before us, then of course the respondent will always have 30 days to file their response. This is normally by way of statement of facts.
Thank you so much. In case you have further questions on how to do it, kindly raise it on the chat box. For those who are joining, welcome.
And we don't have a format for the memorandum of appeal, considering that most of the other parties are unrepresented. So anything that looks like a memorandum of appeal, so long as there are grounds, ideally, so long as you state some grounds why you're objecting the decision, and you do an ordinary statement laying out the basis from the point of assessment through the process you underwent until you came before us, and the necessary documents you think are relevant to your appeal.
Okay, that makes it pretty layman. I mean, easier for the layman rather.
Yes.
Yeah. So thank you so much for that breakdown on how to approach the tribunal. So again, Madam Helen, here I am feeling. We've agreed that you have to be, if you're not infected, you're affected. So I have learned about the HIV and AIDS Tribunal. So how do I approach you? Where do I file the case?
Thank you, Joy. Now, interestingly, most of our litigants are indigent persons. These are people who even coming to file is a problem for them. And so we find that most of them cannot either express themselves very well in written word or even sometimes spoken. So what we do is they will normally raise a complaint. They will file the complaint at the tribunal. This is normally in the form of a letter. So they come, those who can write for themselves will write. Those who can't will come and somebody at the registry will actually write it out for them. So it's in the form of a letter. And then based on that letter, the registry staff is able to assess whether or not this falls within our jurisdiction. So then they will be, if it falls within our jurisdiction, they will be advised on how to prepare something called a statement of claim. We have a basic form, which they just fill in and it forms the statement of claim. Just like in the tax tribunal, we are not too strict on procedure. So anything that looks like statement of claim, a plaint, anything that looks like it has facts or is asking for prayers, we admit it. And then from there on, it just follows more or less the same procedure as court, of course, less rigid. And sometimes you might even find that some parties are completely unable to reduce their complaint into writing. So we just proceed on the basis of oral evidence. But mostly, yes, we're quite informal and they just have to walk in and file the complaint. That's it. Thank you, Joy.
Thank you so much, Madam Namisi. Again, as we continue with the discussions, we're learning that there's no set format for this. So anyone, you don't have to be a lawyer, you can do this. There's no set format as long as you have some valid grounds that can be read. And even in at the HIV and AIDS Tribunal, I had it clearly for those of the complainants who are not able to write it down, there is someone to support them through the way. So again, that makes the tribunal quite approachable. Off we delve to Madam Beatrice. So how do we approach you? The Cooperative Tribunal, tell us. And maybe you also tell us where you are located, like physical locations and where, how do we start?
Thank you, Joy. Cooperative Tribunal deals only with the business of cooperative societies. We have the exclusive and original jurisdiction for cooperative society matters. So any person who is a member, a past member, a deceased member, a nominee or personal representative of a deceased member, or any person demanding from the cooperative society who is a member of that cooperative society, either demanding from the cooperative society or the committee of the cooperative society or any other officer of the cooperative society. You can file a claim either by way of formally what we call a statement of claim, or you can write a letter, or you can fill a form which is available at our registry. Once you file that, the procedure which follows is, of course, you serve the summons, then the respondent files a response to the statement of claim. And after that, if need be, the claimant can also file a reply to the response. For the appellate jurisdiction, parties file a memorandum of appeal. Then the respondent files a response. Then thereafter, directions are issued on how the appeal will be handled. Mostly we do it by way of written submissions for purpose of expeditious dispensation of the matter. We are located at Reinsurance Plaza. The registry and the open courts are on 11th floor, but the chambers and other offices are on 12th floor. Thank you, Joy.
Thank you so much, Beatrice.
Apart from that, we receive documents by way of email in this age of COVID. For filing, we have an email address, which is cooptribunal@customercare@gmail.com. For fixing a date, the email address is cooptribunal.dates@gmail.com. For any other official communication, if the two email addresses are not sufficient, then we have the judiciary email address, which is COPTR, that's Cop Tribunal, coptr@court.go.ke. Thank you, Joy.
Thank you so much. I request that you type that for me, then I can share it on the chat box so that our participants are able to pick it up. So thank you so much again for giving us even the physical location for those of us who didn't know. And I'll bring it back to you, Madam Helen. Where is it? Where does the tribunal sit?
Thank you, Joy. So our main office is at NHIF 15th floor. That's opposite the National Library. We also do have offices outside Nairobi. In the counties, we have an office, a sub-registry in Nyeri, we have one in Kisumu, and we have one in Mombasa. And these are located at the National AIDS Control Council offices. So right next to them, we do have sub-registries. So somebody can just walk in there and file their complaint. And similarly, they can also be able to attend the hearings virtually from those locations. We also do have email, actually services by email. If you want to file a matter, it's by email, and our email address, I will type it out in the chat section. And we are also available or can be found on social media platforms. We are on Twitter, on LinkedIn, on Facebook. So basically, if you want to find us, you will find us. Yes, and as I said, we have basically embraced the virtual court system. And so our litigants don't even need to travel to Nairobi. They can attend court from wherever they are. And if they can't, because as I said, we do have indigent people who appear before us who do not even have a smartphone, then they can simply go to one of those sub-registries in Nakuru, Nyeri, or Kisumu, and they will be able to access the conferencing facility. Thank you, Joy.
Thank you so much. So here we are, Tax Appeals Tribunals. Where do you sit? I want our participants to know where exactly we can fetch you. We've known who you are, your constitution, what cases you handle, but where can we find you?
Yes, the Tax Appeals Tribunal you'll find as a commercial business center. That's the CBC building along Elgon Road, next to Redson Blue Hotel. We are on Block B, first floor. We have two courtrooms there, modern courtrooms, and our secretariat is also on the same floor, and the chambers and our boardrooms are also on the same floor. So you can access us there. We also do online filing. Actually, largely now we are encouraging parties to do online filing. I'll also share the email address, and our proceedings are largely virtual, with a few where parties insist on having to attend court for purpose of where they have witnesses, because 75% of our matters actually are done by way of papers only, without necessarily calling witnesses.
Thank you so much to our three panelists. For those of us who are joining in, Karibuni sana. We are here with Madam Beatrice Kimemia from the Cooperative Tribunal. She chairs the Cooperative Tribunal. We are joined by Eric Nyongesa, who chairs the Tax Appeals Tribunal, and then Madam Helen Namisi, who chairs the HIV and AIDS Tribunal. So we are all kindly reminded to make use of the chat box for the questions that we have. We'll be answering them in the course of the discussion. I want to go to Madam Beatrice. When you were explaining about how do we file, how to file a case in the tribunal, unlike the two other panelists, yours was a bit structured, was a bit serious. So I wanted to know, must you have a lawyer represent you to approach the tribunal?
Thank you, Joy. Before I answer that, I also want to clarify that that is the principal registry is the one at Nairobi.
Okay.
We also do circuits, gazetted sittings in the regions of Meru, Embu, Nyeri, Mombasa, Kisumu, Eldoret, Nakuru, and Kakamega. So parties who want to file online can file online through the official email addresses. If you want to do it physically, we have our registry officials in the said regional offices who receive documents and transmit them to Nairobi. It may look official as a way of filing documents, but in accordance to the nature of cases that are filed in the Cooperative Tribunal, some of them involve very many issues. Some of them involve huge sums of money. For example, if you're dealing with a cooperative society like Stima Sacco versus Mwalimu Sacco, you see, it would be necessary to file the proper documents and the witness statements together with the official, or so to say, under civil procedure rules, the pleadings which are in order so that we are able to follow up with the issues. But for any other person who feels that their matter is simple enough, you can either represent yourself, even the circles sometimes, or the cooperative societies represent themselves. So there is no bar against any individual representing themselves or acting through another person whom you can nominate or through an advocate. We try to be unofficial even in the proceedings so that anybody and everybody can understand what is happening during the proceedings. Thank you, Joy.
Thank you so much for breaking it down just as I expected. I know we are joined in by laymen in here, not everyone is an advocate, so it's quite, I believe it's quite proper just to ensure that they feel well addressed. So for the same question, I want to ask you, Helen, must I, well, from what you've explained, I don't think you need an advocate, but can I engage the services of an advocate to come file a case in the tribunal?
Thank you, Joy. So yes, you do not need an advocate. You can actually represent yourself at the tribunal. And interestingly, our act actually allows a person to be represented by someone other than an advocate. So we have had instances where you have community health workers or volunteers actually appearing and representing an individual or another. And then if you wish, you can have an advocate. But as I said, most of our litigants are actually indigent. And so we find that a lot of them do come unrepresented, and some of them do request for representation. And in such instances, where we feel that this person's case will not be articulated well without the help of an advocate, then we do refer them to organizations that we have partnered with. For example, we have Kituo cha Sheria, we have FIDA Kenya. So we send them over to them so that they can be represented. We do also have a list of pro bono lawyers that have offered their services to these litigants and are able to represent them because, as you can imagine, Joy, these are people, sometimes, you know, basic grassroots, the person from the plot, kijiji kabisa, they are completely unable to articulate their issues. And sometimes they're going up against respondents who may have what we like to call as the Ivy League firms representing them. So definitely this person would require legal representation just to be able to articulate their case very well. So in such instances, we do refer them to the institutions or to pro bono advocates who have offered their services. But no, you don't need to be represented. You can represent yourself. It's fairly simple. As I said, if you look at the composition of the tribunal, we have non-lawyers. So even for the sake of the non-lawyers, we try to keep the procedure simple and straightforward that anybody can understand. Thank you, Joy.
Thank you so much. So we've had it from the three panelists. You don't have to have a lawyer. You can self-represent. And for the more sensitive one, like the HIV and AIDS Tribunal, yes, you're allowed to be represented by a lawyer and someone else, or someone else who's not a lawyer. Okay, thank you so much for that. So I'll start with the gent again, Mr. Eric. So
Yes.
serious, what's up? It's Friday, cheer up.
Yes,
So
yes.
what is the average
cold.
cost of?
It's very cold.
Yeah, it's really cold. Let's warm it up. So
Yes.
what is the average cost of filing a case from start to stop, from start to determination? An average cost. I know it's really hard to say it's 10,000, it's 1,000, but just an average cost. Let us know.
Joy, before I answer that question, I think the other aspect that you dealt with in terms of representation,
Okay.
I think I need to make some comments on behalf of the tribunal. Representation at the tribunal, you can represent yourself, or the act says you can be represented by a tax agent or an advocate. Many times we advise that the parties to get an advocate or an agent. Tax is a matter of legal interpretation. And how many lawyers can even interpret their own tax liability? It's a strict issue. So you find that self-representation, unless you are well knowledgeable, you have a bit of background in tax, or an advocate, you may not be able to interpret the legislation appropriately. So most of them will want to advise parties to get some advocates, and that's where advocates will want to. Unfortunately, we have more tax agents. I think 75% of representations by tax agents. We are seeing few advocates coming in through, but largely you can self-represent, but there are also procedures. So you need to acquaint yourself if you are self-representing yourself. In terms of fees, I think we are among the cheapest tribunals. We just have a fixed statutory sum. When approaching the tribunal, you need to pay 20,000. It's a fixed by statute, and that covers all processes before the tribunal. So once you pay 20,000, you get your proceedings without paying anything else. We'll certify for you, give you a copy of the judgment. All other processes, you not pay for them. So it's a fixed statutory sum of 20,000, fixed by statute. So the cost is that. You just need 20,000, whatever the amount involved. Unfortunately, that also affects some people may want to put claims for small amounts, but from practice, since the tribunal commenced in 2015, I've hardly seen somebody coming there with a tax dispute of less than 100,000. Mostly they run into billions and millions. So most of the other people will sort it out through the ADR processes that are there with KRA. So most of the times the figures that we deal with are substantive, and therefore 20,000 is not a very big amount compared to the tax liabilities involved.
Members, there you have it, 20,000 and you are sorted. No hidden charges, nothing, 20,000. So Madam Helen, to approach your tribunal, you as a chairperson, tell us, how much do we need?
Absolutely nothing. We don't charge fees. So you will come, you will file all your documents for free. Absolutely nothing. The only thing you will pay is for your transport to get to the tribunal, or for your bundles to send your emails or to log in, and obviously your advocate. But to the tribunal, you will pay nothing.
Wow. And here we thought that the Tax Appeals Tribunals was the cheapest. Madam Helen wins on the cheapest, which is free. And I hope to hear something along the same lines with Madam Beatrice. How much is it to file a case at the tribunal, the Cooperative Tribunal?
Thank you, Joy. Ours, we have a formula. We have the principal amount, you less 6,000. Then you multiply by 20%. You add 780 and another 100 shillings. Let me explain. For a claim or a counterclaim of a liquidated amount of less than 6,000 shillings, the fees is 780. Then you add 100 shillings for the summons. And for every liquidated or unliquidated prayer, it is 1,000 shillings. For any other document, it's 50 shillings, except submissions and affidavits, which are 75 shillings. But however, for any other amount, there may be very colossal amount. The maximum fees charged is 70,000 shillings. So the minimum is 780, maximum 70,000.
Quite well explained. The mathematicians in their house, you got that. The principal, I hope I get this right. Principal less 6,000 times 20, then whatever figure you get there, add 780 plus 100. Is that so?
20%.
Oh, come again?
It's 20%.
Or 20%, or 20%, 20%.
Yes.
I got the 20
Yes.
at least. So thank
Yes.
you. Thank you so much for that. So allow me to go back to you, Mr. Eric Nyongesa, for the Tax Appeal Tribunals. You paid your 20,000, everything, you have it right. So how long should this take? How long does the case averagely take?
On average, currently it's we'll put it at about 6 months. The reason being that when you file a case, there is a provision that you can go for ADR, and the ADR, the statute permits you to have 90 days. So most parties, when the pleadings are closed and the matter is coming up for pre-trials, they'll ask to go for ADR, and they'll always want to ask for their 90 days. So you'll find that if you have filed, the other party will file a response within 30 days. Then after that, somebody will have 90 days. Then normally for a simple matter, because it will just be a document only, most parties will proceed by off submissions. The other 3 months, we should be able to hear you. Though that has not been the practice as simple as that. For reasons that from 2015, we have had a bit of challenges. There was a time when the tribunal didn't have members after the first term of the first members lapsed. For about 14 months, we didn't have members. So we have a huge backlog, considering that we had a backlog from 2015, which we just cleared up to 2018 the other day. And some of the files can be heavy, very bulky. And you may have so many experts. You may have one file where you have almost 6-9 experts on different aspects of taxes, especially for multinationals, which have some elements of some international tax. So for a simple tax, we give it 6 months. The other ones can take even the panel to go to a retreat. Sometimes we go for a retreat, the entire tribunal, so that we can be able to build some position, develop a common position to look at the various competing professional and expert advice we have. So that's where we are.
So we can talk about 6 months on a case-to-case basis. Well,
the Act expects that will be 90 days. That's what the Act expects. Initially, the Act in 2015 was 45 days. Now it suggests 90 days. But when you talk of 90 and you have ADR, that is not very possible. But hopefully by June next year, we'll be working with about 6 months for sure.
Oh, great.
Yes.
So great. Thank you so much. So each case is different. We must understand that. That has been explained very well by Mr. Nyongesa. And to you, Beatrice, how long will a case take once it's filed at the tribunal, the Cooperative Tribunal to be specific?
Thank you, Joy. Once the pleadings close, that is after 21 days, Then we set down the matter for hearing. That now depends on the complexity of the matter. If it is a matter for refunds, then we do it through summary proceedings, because it is clear somebody deposited their savings in the cooperative society, they now wish to withdraw. So if there are no attaching liabilities in the form of loans or guarantors, then they file submissions and then they get their award. For cases where we are adopting the surcharge orders of the Commissioner of Cooperative, then that is also a short period of time. We can say maybe 3 months. Now, due to the heavy workload and the heavy backlog in the Cooperative Tribunal, you can give or take 6 to 12 months at best. This is now depending on the complexity of the matter, the issues involved, but we try to expedite the matters where there are no many issues, like the refunds, the adoption of the summary, and even appeals. Just that sometimes the parties take long to move their matters, but we are always ready to do any matter between a period of 6 to 12 months, minimum 3 months. Thank you, Joy.
Thank you so much. Minimum 3 months, but within a period of 6 months to 12 months on a case-to-case basis. Cases differ, complex matters are expected to take longer. So, Madam Helen, how long do we expect a case to take once it's filed at the HIV and AIDS Tribunal?
Our current target is to complete matters within 6 months. But just as Ms. Kimemia has said, sometimes the parties themselves are the ones who drag the matters. So for us on our part, as soon as the pleadings close, we are ready to give you a hearing date. I think some advocates who've appeared before us are shocked when they come and we tell them hearing in 2 weeks. And then, you know, we are ready to hear you. The question is whether the parties are ready to be heard, but our target is 6 months.
Great. So when you look at what has been presented by the 3 panelists, the average is 6 months, again, 6 to 12 months, depending on the complexity of the matter. So I want to take a question from the chat box. This question is directed to you, Mr. Nyongesa, who's the chairperson. For those who've joined us, karibuni, the number of people who've joined in, and kindly make use of the chat box where I'll be picking questions that will be addressed by our very knowledgeable panelists. So the first question is on where the Tax Appeal Tribunal sits. That has been responded to, and you can also check the chat box. The details have been given there in detail. How often does the tribunal sit? Kindly unmute yourself, sir. Mr. Nyongesa, kindly unmute yourself. Great.
Yes. Sorry, I was dealing with my battery was running low. I was just putting a charger. Now, the tribunal, we've been trying to sit during the beginning of the year because we had a huge backlog, and we are trying to clear the backlog from 2015 to 2018. From the 25th of January up to end of June, the tribunal was sitting every day of the week. Currently, what we have is that the tribunal is sitting 4 times a month. When the tribunal sits, each panel, every time they sit, they have like about 15 to 20 matters. So what we are trying to do is that we want them to, once they have accumulated about 40 judgments, then they have to retreat until they complete those judgments. This is informed by the reasons that the terms of the members come to an end at different times. And we've had situations whereby if you accumulate too many judgments, then the terms of some members comes to an end, and then you have to have those some matters had again de novo and all those complexions. So what we are trying to do is to avoid that situation. We accumulate a particular number of judgments. Like currently we've started hearings this month, next month, and October. Each panel will accumulate about 60 judgments. Then we expect them to go and read judgments and conclude them by the end of the year. Then in January, we'll have another set of hearings.
Thank you. Thank you
Yes.
so much. So, Madam Helen, how often does the tribunal sit?
Thanks, Joy. We sit once a week, normally on Fridays, but sometimes we do extend and sit twice a week on Thursday and Friday. But the normal day is Friday.
Friday. Today is the day.
Yes.
Great. Madam Beatrice, how many times in a week, in a month, how often do you sit?
Thank you, Joy. The Cooperative Tribunal is a full-time tribunal. This is because of the heavy workload and heavy work backlog, as I had indicated earlier. Every second week of the month, we have the gazetted circuit sittings in the regions. Then after that, we ensure that we have 1 week sitting in Nairobi, 1 week virtual mentions, and then 1 week for deliberations for purposes of writing rulings and judgments or awards. Thank you.
Thank you so much. Now we know when to approach which tribunal, and this should be an encouragement to us participants. There's so many tribunals. This has been a series, and every time we have representatives from the various tribunals. So the more you keep up with them, the more you get to learn where you can get assistance. So again, a quick reminder, make use of the chat box. I'm seeing people are still streaming in. On your screen, there's a feedback poll. Kindly take a few minutes as we proceed so that you can be able to give us feedback on how to deliver, and maybe if we've delivered, so that we can have a tap on our backs. So as you continue filling, that should just take you a few minutes. It's a set of around 5 questions, which will take not more than 2 minutes. Yeah, you can fill in that. As our participants continue with the feedback session, which I believe should be wrapping up, there are just pretty simple questions that mean much to us. I'd like to ask Mr. Nyongesa again, why would one choose to file at the tribunal and not any other court? Why is there a specific reason why one should approach the tax appeal tribunals and just not the ordinary court?
Yeah, thank you, Joy. One of the things that you need to appreciate that the tribunal is set up by the Tax Appeals Tribunal Act, and its processes are guided by the Tax Procedures Act, and you also have rules, Tax Appeals Tribunal Procedure Rules 2015. The two statutes, the Tax Appeals Tribunal Act and the Tax Procedures Act, confer specific jurisdiction to the tribunal when it comes to tax appeals, when you are appealing against a tax decision of the commission. So that if you went to another court, the court will not have jurisdiction. So you find that the only reason you'll have any recourse to another court, and more specifically the High Court, will be when you are challenging the constitutionality of a tax decision or a tax statute. You can see the minimum tax. The other day, there's a matter pending in court. That's a jurisdiction of the High Court. Or when you are challenging procedural propriety of the decision, when you are not challenging the merit of the decision, but how it was arrived at, then you can go for JR in the High Court. But any other matter, the High Court will refer you back to us. So our jurisdiction is conferred by statute and is very specific.
Having mentioned about,
yes.
Sorry, go ahead.
Yeah, so that's what I was saying. Basically, you cannot escape from coming to us when it means you are appealing against a tax decision.
Okay.
Yes.
Okay, a follow-up question on the response that you've just given us. So
Yes.
are there any rules of procedure, or how does one prosecute or defend the case?
Yes, the Tax Procedures Act, which is the substantive statute in terms of procedures before the tribunal, and which also gives you, as a taxpayer, and in fact, not even as a lawyer, as a taxpayer, just a taxpayer, if there's any statute that you must read, is the Tax Procedures Act. One, it also confers to you your rights as a taxpayer, so that you know what the commissioner can do and what he cannot do. And when you receive an assessment or demand, what you need to do, even how to lodge your objection with the commissioner, the timelines, and what timelines. For instance, if the commissioner has given you an assessment, you have 30 days to lodge an objection. And the commissioner is bound to give you a decision within 60 days. If the commissioner does not give you a decision within 60 days, it is assumed by law that then he has accepted your objection. So you can now not enforce that tax. Sometimes there are always lapses where the commissioner goes to sleep. And when they try to enforce, then somebody comes back to us and we remind the commissioner that you slept, you should have acted within 60 days. And it's very clear. So that provides the substantive procedures before the tribunal. But in terms of our processes, we have the Tax Appeals Tribunal Procedure Rules of 2015, which were amended under the Act. They were also amended in March this year, so that to provide for service. So processes, now we can serve you by way of WhatsApp and service by way of email. So it just simplifies the process and also legitimizes our online hearings through the amendments that came in this year. So we have those procedures. So you need to look at the rules.
Oh, great.
Yes, yeah.
There you have it on the procedure. On to you, Beatrice Timemir. What is the one reason that I will have to approach the tribunal rather than going straight to court? Kindly unmute yourself.
Thank you, Joy. Under Section 76 Cooperative Societies Act and Section 67 of the SASRA. SASRA is a SACCO Societies Regulation Act. The tribunal has the exclusive and original jurisdiction in the businesses involving cooperative societies. Number two, we also have the appellate jurisdiction for the surcharge orders filed by the commissioner. The commissioner or the cooperative society involved in the surcharge orders should file the surcharge orders after the expiry of 30 days, that is the appeal period, so that the same can be adopted as an award of the tribunal so that the cooperative society is able to execute. If the surcharge order is not adopted and there is an appeal filed, then we go ahead and set down the appeal for hearing and determination. In this regard, the procedure rules, we rely heavily on the Cooperative Societies Act. The SASRA Act just gives jurisdiction to the Cooperative Tribunal under Section 67. Then we also rely on the Civil Procedure Rules, the Cooperative Tribunal Practice and Procedure Rules, and the SASRA rules. In case any party is challenging the administrative action of the commissioner, then they file a judicial review in the High Court. We do not rely heavily on the law of evidence because it is precluded in the Act. So we just do equity. But depending on the nature of the case, then we see what to preclude in terms of evidence or not. Thank you, Jay. You are muted.
Having been the one who's reminding everyone, kindly unmute yourself. Technology is challenging on a Friday. Thank you so much. So I wanted to ask you, Are there any rules of procedure, or how does one prosecute the case or defend the case?
Basically, we are not as serious as the court in following the procedure rules. So when a party files, we only require them to file the witness statements and documents. When the matter comes up for hearing, the parties adopt their witness statements, they go on to cross-examine, and then after that, they file submissions if need be, and then we give the award. For the other simple matters, they just file submissions, and then we give the award. For the appeals, same case. Appeal is filed, a memorandum of appeal, but in this instance, there are various documents which are required under the Cooperative Tribunal Practice and Procedure Rules, which should be filed together with a memorandum of appeal. Thereafter, the other party responds, and then parties file their submissions, and then we give the judgment. So basically, we rely on the Cooperative Tribunal Practice and Procedure Rules and Civil Procedure Rules, and also the SASRA rules, if need be. Thank you, Joy.
Thank you so much, Madam Beatrice, for that, the clarity you shared in terms of procedure and the reason why one would have to approach the tribunal first. Last again, but not least, definitely, Helen, why would I have to approach the HIV and AIDS Tribunal first?
Thanks, Joy. So unlike the Tax Tribunal and Cooperative Tribunal, for us, it's not written in the act that you must come to the HIV tribunal first. So why would it be important for you to start with us? One, we are specialized. Two, there's the element of confidentiality that you will not enjoy in other courts because our proceedings are in camera. We do not indicate the identity of the individuals who come. Basically, we ensure confidentiality because remember, I said one of the breaches of the act is a disclosure of one's status. So we do not want to be guilty of the same offense. It's cheaper. We are less rigid. It's quite flexible. We are faster than the courts. We are friendlier. In fact, for the advocates who used to practice with us before COVID, they would have told you that they always enjoyed a cup of tea in the morning and a few samosas. But unfortunately, COVID has taken that away. So now they just enjoy virtual samosas and tea. And also starting with the tribunal gives you more chances of appeal because then from us, you can appeal to the High Court, then the Court of Appeal, and perhaps if you're lucky, even to the Supreme Court, as opposed to starting at the High Court where then you're just limited to appealing to the Court of Appeal only. So I would say the tribunal is a place to start for these offenses, yes.
There you have it. HIV and AIDS Tribunal, it's not cast on stone that you have to start there, but it gives you a softer landing, definitely from what Madam Namisi has explained to us. So a question that we'll cut across as we come to wind up, that is 2 minutes past the desired time. I wanted to raise it with our panelists, whether we have a program, a pro bono lawyers scheme or program in our tribunals that can support the clients who approach us. So I'll start with our gentleman, Mr. Nyongesa.
Yes, unfortunately, with the Tax Appeals Tribunal, we do not have a pro bono program. Largely, tax is an individual responsibility. It may not have a public element to your specific tax issue. So I don't think there has been that good basis why they should have a pro bono service to take care of your individual liability. But we are trying to create synergy with other institutions and see how we can make the place more friendly and maybe help those who may not be able to afford an agent. But largely, like I said, because of the amounts involved, largely the Revenue Authority has not been very aggressive against small taxpayers. Chasing small taxpayers may be too expensive. So what has been happening is that most of the matters filed are filed by the large taxpayers. So those ones obviously don't need pro bono services. So until such a time that we start getting the common man in the street coming before us, maybe need may arise. But from the nature of the matters we have so far, there's absolutely no need for pro bono services.
There you have it. Your tax is your personal responsibility. Next, Madam Helen, is there such a scheme for those who may not afford the legal services? Well, I'm not sure what that would mean because it's free, but maybe someone just needs a professional to guide them.
I think for us now, we're on the other end of the spectrum because the people who come to us are the common mwananchi. It is the mama mboga on the street, the gentleman selling your charcoal, the conductor in the matatu. Those are the ones who come to us. So yes, we do have a pro bono lawyers scheme. It's still open. We're looking for advocates to join. It's an interesting place to practice the tribunal, even especially for those who are just newly admitted. It's a nice soft landing before you find yourself in the Court of Appeal. You know, you can try and grow your wings in the tribunal. So yes, we do have a pro bono lawyer scheme. It is open. We are hoping that we have more lawyers joining it. And as I said, we also partner with Kituo cha Sheria and FIDA Kenya to help some of these indigent clients be able to articulate their cases before us. Thank you, Joy.
Thank you. Before I let you go, Madam Helen, would you let us know an interested person like Joy, who's an advocate, how will they join the scheme?
That's very simple. You just send us an email and indicate your interest in joining the pro bono lawyers scheme. That's all. And then we'll be able to contact you, give you the many cases that we have for you to take up. Yes.
Oh, great. Oh, great. Thank you. So for our followers, there you have it. If you're interested rather in supporting the work of the tribunal, you can check it up with Madam Helen. The details have been dropped on our chat box. There's the email. I can see there's an email, there's the physical address, there's a phone number, Twitter, all social media handles are there. So you can reach out and give back to the community. Lastly, but not least, Beatrice, do we have pro bono lawyers that represent the clients who approach the tribunal?
Thank you, Joy. For the Cooperative Tribunal, we do not have that yet. And the reason why we do not need pro bono lawyers is because, number one, a person can nominate another person to represent them. Number two, you can also act for yourself. Number three, the fees are reasonable. Number four, the procedure is simple. It is for the ordinary mwananchi. So interestingly enough, we find that the cases in which parties are acting in person move much more faster than those with advocates, because ordinarily as advocates, we tend to get into the glitches of technicalities of which the tribunal does not descend to. Number two, we want to attend to each person individually, whether you have an advocate, a nominated person, or you are coming as an individual. We are a friendly tribunal, not as rigid as the formal court. Thank you, Joy.
Thank you so much, Beatrice. A whole lot of reasons why they do not have a pro bono lawyer scheme, and each of every reason that she's given stands. They are quite affordable. From the discussions that we had at the beginning of the session, the procedure is not that complicated, honestly. And she had listed a whole number of people that can approach the tribunal. So you can't fail 1, 2, 3 people around you who can approach the tribunal on your behalf if you feel that you lack the capacity to do so. So as we come to the tail end of our discussions, I want to take this opportunity to give each panelist a minute or two, maybe to tell us something that I may have missed out in my interview. This was more like an interview. Maybe there's something that you really wanted to share with our followers, and also a constant reminder to our followers, the chat box remains open. For those of us who had shared questions, I believe they've all been addressed. There are those that I maybe didn't read out, it's because during the session, the panelists addressed them. So this time, again, I will start with the gent, Mr. Eric. Any parting shots as we wrap up our session today?
Thank you, Joy. And for the colleagues who logged in, One of the things that I want to say is that, like they say, tax is your responsibility. The tribunal is not the tax authority. The tribunal is an arbiter between the taxpayer and the authority. We've been able to come up with many decisions, and our decisions can be found on the Kenya Law Report. Every week, the decisions we make, they always posted on Kenya Law Report, so you can always access our decisions and understand the business we do. It's unfortunate that advocates think that tax is about accounts. Tax is about interpretation. Before you go and work on your account, you must interpret. Like the very simple thing of income tax, it's about whether you made a profit or made a loss. It's that simple. So it's about what you earned and what your expenses were. And that's an interpretation of the law. The law says it's your profits, but it must be an income. So you find that advocates, let's start looking at our own personal accounts. The moment we appreciate our own simple accounts, we'll also be able to understand tax. And if we can be able to manage our own taxes, then we'll be able to interpret the tax statutes for our clients. It's very unfortunate that 75% of the people coming before us are tax agents who know about the science of the accounts, but not the science of the law in terms of interpretation. So I challenge you, please take up a queue. Now we have become a very vibrant tribunal. You're already aware that there is a statute, there's an amendment bill in Parliament, which the tribunal will be trying to be sitting more often, and we are likely to have more business for you. We have a minimum 5 appeals filed every day, so there's a lot of work. There's a good niche area for you to earn a full living as a practitioner. So please take up this space. Don't leave it for other people. That's all I'm saying. Please take it up and let's build up jurisprudence in that area. We'll be happier to have most of you practicing there. Thank you.
Tax is your responsibility. Advocates, you've been challenged, advocates in the house and everyone in the house, you've been challenged to first understand the simple accounts that you hold, and finally harness on the vacuum. It's an opportunity that lives with us, and you've been reminded of the need to leverage on it, harnessing on the vacuum. So thank you so much, Mr. Nyongesa, for your time, for your time, and for sharing the wealth of knowledge. Clearly, we've seen where the 23 years stand at. There's so much that we've learned, and the webinar has been streaming live on our Facebook page. So in case you came in late and you missed out on something, you can follow us on our Facebook page, and you can even watch the entire webinar so that you can catch up with what you might have missed when we began the webinar at 2. So
thank you, Joy.
Yes, asante sana. Madam Beatrice Kimemia, what do you have to tell us as we wind up on this beautiful Friday?
Thank you, Joy. I wanted to clarify that under Section 78 Cooperative Societies Act, the Cooperative Tribunal is not bound by the rules of evidence. Number 2, under Section 81, we find that the tribunal in its jurisdiction decides all matters in regard to cooperative societies. You can only appeal once to the High Court. The decision of the High Court is final.
You've muted. Madam Beatrice, you've muted. We can't hear you.
You muted me, Joy.
Well, they must have, sorry.
Yes, I was saying the decision of the High Court on appeal on the tribunal's decision is final. So the parties do not have the advantage of going to the Court of Appeal unless now they seek leave from the Court of Appeal. For the JR, the parties go to the High Court. The Cooperative Tribunal is diligent in determining issues that are in regard to cooperative societies, and we aspire to have an expeditious disposal of cases that are before us. The last point I want to make, Joy, is that the Cooperative Tribunal has an inherent power to make any decision or any orders to the ends of justice. This is different from the court system, where when you file an application, then the court determines the prayers that are in the application. In the Cooperative Tribunal, we can give any orders or make any decision in regard to any matter that is before us, so that we meet the ends of justice. Finally, thank you for hosting. Thank you, my fellow chairpersons. It is interesting to hear what other tribunals do. And in case you have any other questions, you can float them. I will answer. Thank you, Joy.
Wow, thank you so much. There you have it, not bound by Cap 80. The rules of evidence do not apply to them. It's not bound by the rules of evidence. That has come out clearly from the point we began to this point. So, and what more can I say? What more can I say? Mine is to say a big thank you for your time, for the knowledge that you've shared with us, and even the willingness to have us follow you through the contact details that you shared on the chat box for areas that may still seem gray to us as the followers. So thank you so much, Madam Beatrice Kimemia, and have a lovely weekend. Lastly, but not least, I've used you on the lastly, but not least so many times, and for real, it's not the least. Madam Helen, what do you have to tell us about your tribunal?
I think now I'm feeling very least.
I have the least. I have the last.
Thank you, Joy. Thank you for moderating this session quite well. So a few parting shots. One, I know that HIV and AIDS is not a topic that we like to discuss. And that is also a reason why, until today, for something that began in the 1980s, we are still grappling with the pandemic till now in this country. And if you look at the statistics, Kenya is not doing very well in terms of the new infections. And this is basically because of the stigma that is related with HIV and AIDS. And the minute we address the stigma as a community, as a society, then we will be able to deal with the new infections, the spread, and the control. Because as we have seen, because of stigma, people do not get tested, they do not want to take their ARVs, they do not want to inform their partners that they are positive or otherwise, just because of stigma. And if you want to relate stigma, I know for most people, stigma might not be real, but I think a good analogy is COVID last year, how people related to those who were positive, COVID positive last year. So you can imagine somebody who has to live with that every single day of their lives since, I don't know, the 1980s or early 90s. And so we need to really look at persons living with HIV in a positive light. Some of them may outlive us, despite the fact that we think that they are not healthy. Now, another thing that we have to realize as Kenyans is that we have a fantastic opportunity. This tribunal is the only one of its kind in the world. It is a feather in our cap as Kenyans. In addition to being great marathon runners, we have an HIV and AIDS tribunal. So why not take advantage of this opportunity? This is an area for lawyers to practice, for the public to bring their cases. And as I said, it is a feather in our cap. Let us use it so that out there we are known not just as long distance runners, but also as the people who have actually gone a long way in addressing the pandemic in the world. And that is it from me. Thank you, Joy.
Thank you so much, Helen, for the beautiful remarks as we come to the end. For those of us who joined us late, the chat box still remains open. A quick reminder to follow us on our social media to be able to catch up with the discussions that have transpired in the last 1 hour, 20 minutes. If you still have questions, you can direct them to the specific panelists through the contacts that they shared on the chat box. If you're not able to access that because you maybe came in late or left and rejoined, kindly you can leave the questions on the Facebook page and they'll be addressed to accordingly. From the list, yes, Helen, mine is a big thank you to all the panelists. It was a nice one. It was it was informative. It was both eye-opening for those of us who are listening. You've heard of the opportunities that lie within the HIV and AIDS Tribunal, in the Tax Appeals Tribunal, and also in the Cooperative Tribunal. What stood out for me, and I must believe to many of us who are following, is how simple it is and quite affordable to approach these tribunals. So hakuna Kiswahili, hakuna kipingamizi ama pingamizi. There's nothing that really stands in between you and approaching the tribunal. Reasons for approaching the tribunals have been given. The pros, I mean, it's always a soft landing for those of us like Helen's tribunal. It's easier when you start there. Others, it's mandatory that you stand there. You start there. So with those many remarks, I want to wish you a nice afternoon and a blessed weekend. Stay safe, keep warm, and follow us on our social media pages so that you can be able to catch up with the next series of learning about our tribunals. So from the committee and LSK, we want to say thank you, see you next time, and have a very nice weekend. Bye.
Bye.